Today, we will explore the application of the so-called Qualified Personal Residence Trust, or QPRT, in effective estate tax planning. But first, a brief introduction. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the great states of Florida and Texas. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, as well as a bachelor's degree in accounting and a master's degree in federal income taxation, in addition to 10 professional licenses and certifications spanning accounting, tax, audit, and of course, the law. My firm website is www.cummings.law. A qualified personal residence trust, or QPRT, is a complicated, sophisticated estate planning tool that allows homeowners to transfer their residence out of their taxable estate, thereby potentially reducing estate taxes. QPRTs involve transferring ownership of a personal residence to a special type of trust whilst retaining the right to live in the home for a specified period. Following this term, the residence typically transfers to the designated beneficiaries, often children or other heirs. The primary advantage of a QPRT is its ability to freeze the value of the residence for estate tax purposes at the time the trust is created and funded. This strategy can be particularly beneficial in high appreciation real estate markets. By transferring a residence to a QPRT, any future appreciation of the property's value is shifted out of the taxable estate of the grantor, effectively reducing potential estate tax liabilities. However, QPRTs are not without their nuances and potential drawbacks. It is crucial to understand the specific requirements and potential pitfalls before implementing this strategy. The long-term success of a QPRT largely hinges on proper structuring and careful consideration of the grantor's objectives and circumstances. Let's talk about maximizing tax efficiency. One of the key benefits of a QPRT is the opportunity to leverage the federal gift tax exemption effectively. When a residence is transferred into a QPRT, the gift value is calculated based on the property's value at the time of the transfer, minus the retained interest of the grantor to reside in the home for that specified period of time. This retained interest is valued using IRS actuarial tables, which may significantly reduce the taxable value of the gift. To maximize tax efficiency, it is imperative to transfer the property into the QPRT when home values are relatively stable or low, ensuring the most significant possible reduction in taxable value. Furthermore, selecting a longer trust term can potentially enhance tax benefits as the retained interest effectively decreases the gift value. However, the grantor must, repeat, must outlive the trust term for the full tax benefits to be realized. Let's talk more about choosing the appropriate trust term. Determining the optimal term for a QPRT is a critical decision that can significantly impact the effectiveness of the trust. The term should strike a balance between maximizing tax benefits and ensuring that the grantor's needs and life expectancy are appropriately considered. A longer term reduces the gift value, thus enhancing tax benefits. However, it also increases the risk that the grantor might not survive the term, which would seriously negate the anticipated tax advantages. When selecting the term, consider factors such as the grantor's age, health, financial, and family situation. Additionally, the anticipated appreciation of the residence and the grantor's housing needs following the term should be closely scrutinized. A well considered term maximizes the likelihood of achieving the desired estate planning outcomes while minimizing the pertinent risks. It is also essential to have contingency plans in place. Should the grantor outlive the trust term, arrangements for renting the home back from the beneficiaries or securing alternative housing must be considered at the outset. Let's talk about addressing potential risks and challenges. Now, while a QPRT offers significant benefits when implemented correctly, it also presents certain challenges and substantial risks. And one of those risks is the possibility of the grantor not surviving the trust term. If this occurs, the residence reverts to the grantor's estate and the anticipated tax benefits dissipate. Thus, the selection of an appropriate trust term is paramount. Another consideration is the potential impact on the grantor's financial situation. Once the trust term concludes, the grantor no longer owns the residence and must either rent it from the beneficiaries or vacate. This scenario necessitates careful planning to ensure the grantor's financial stability and housing needs are satisfied post-term. Moreover, changes in family dynamics or real estate markets can significantly affect the viability and desirability of a QPRT. Regular reviews and potential adjustments to the estate plan are strongly indicated to address these variables. Consulting with a qualified tax attorney and CPA is essential to navigate these complexities and devise a tailored, workable, and defensible strategy. To fully leverage the benefits of a QPRT, it should be integrated into a broader, comprehensive estate plan. In other words, a QPRT should never be a standalone document. This involves coordinating with other estate planning tools such as wills, different varieties of trusts, and life insurance policies to ensure a cohesive strategy that aligns with the grantor's overall objectives. Consideration should also be given to how the transfer of the residence affects other aspects of the estate plan, including, importantly, liquidity needs and the treatment of other assets. A holistic, comprehensive approach ensures that the grantor's broader financial and familial goals are addressed while optimizing tax efficiencies. For further guidance on estate planning in general and QPRTs specifically, I invite you to schedule time to speak with me. Again, my name is Chad Cummings, and I hope that you found this information useful. As always, the information in this presentation is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.